Welcome to this, I think, very special, important event on fidelity and change in constitutional interpretation. My name is Richard Albert. I teach constitutional law here at the law school, and it's really an honor to welcome to BC Jack and Larry and Jim, who's been here many times, and to have Katie here with us on the panel. I'm going to say a very short few words by way of introduction, and then I'll turn over the floor to Jim Fleming, who will host our panel as an active moderator, which is what he's been invited to do. But before I just say a few words about our guests, let me take a moment to thank Vlad Perjou, who is the director of the Clough Center. Vlad, I tell you this every time you host an event of this scale at BC, which is almost every week, more than once a week, many times. You've really done so much to enliven our community with discussions of comparative, theoretical, historical, doctrinal elements of constitutional law, and it's a great gift you've given us. You really have brought the world to Boston College in many ways, so thank you for everything you've done for BC. So today we have a great group of panelists to talk about constitutional interpretation, the stakes, the implications, the consequences of how we interpret this thing called a constitution, which of course, as you know, can be both a text and an unwritten, uncodified thing. And we have a great group here for us to discuss all of these subjects. We have Jack Balkin, who joins us from the Yale Law School. Jack is, of course, an accomplished author. Some have called him the leading scholar of his generation in constitutional law. It's really a pleasure to have him here. I won't list all of his books. You can find those on his bio, but I will tell you, if you don't know, that he runs one of the most active blogs for scholars. It's called Balkanization, a consequence of Jack Balkin. And we also have Lawrence Solum here, seated to Jack's right. Larry joins us from Georgetown, previously at the University of Illinois. Larry is a leading, perhaps the leading legal theorist, and he joins us today to give us his perspectives on interpretation. And I will also add that Larry also runs an important blog called the Legal Theory Blog, and I want to commend this especially to law students here, because once a week he has a very important feature that helps explain something important in law, whether it's the distinction between rules and standards, whether it's constitutional interpretation as a theme. Larry will help you navigate important subjects in the first year, second, third year curriculum, and it's very, very well done. Katharine Young, of course, our own Katharine Young, is here, an associate professor at the law school, already a leading scholar in the field of socioeconomic rights and the interpretation of constitutions, and also thinking about the role of courts. What should courts do? How should they interpret constitutions in order to perfect democracy? So it's a pleasure to have Katie here on the panel. I'm going to cede the floor to Jim Fleming, who will be our active moderator. Jim joins us from down the street at BU. He is one of the most active organizers, I would say, in all of the legal academy. Every year he organizes multiple events. I'm not sure how he does it, alongside the excellent scholarship that he produces on constitutional interpretation, on constitutional law, all fields of public law, in fact. So it's really a pleasure to have Jim here. Jim, thank you very much for leading our discussion today, and thank you to all of you for being here.
Thank you, Richard, and thank you, Vlad. You're doing a marvelous job with your center. Put on terrific programming, and it's an honor and a pleasure to be a part of it. Now, Richard asked me to serve as, quote, active moderator, close quote, for this panel, and I'm honored to accept this responsibility. And so I envision the panel not as each person making a traditional presentation of their work or outlining their general views on fidelity and change in constitutional interpretation for 15 minutes each, and then us running out of time and not having a chance to have a discussion. Instead, I envision this as a conversation among us about where constitutional theory is at the present time, with respect to certain basic questions about fidelity and change in constitutional interpretation. Now, fidelity is typically associated with originalism, and change is typically the rhetoric of living constitutionalism. But many, like Jack, have argued that no, the two are not incompatible. And Jack has tried to synthesize these aspirations to fidelity and also to account for change through his theory of living originalism. And Larry, in his co-authored book, Constitutional Originalism, A Debate, it was a debate between originalism and living constitutionalism, has pointed out many areas of compatibility between at least certain forms of originalism and certain reasonable forms of living constitutionalism. So I want to begin by just posing a very general question. Where are we in the debates between originalisms and living constitutionalisms? And I always use those terms in the plural because there has been a proliferation of originalisms. I speak of the Balkanization of originalism and the Balkanization of originalism. The Balkanization of originalism is what happens when originalism splits into a number of warring camps. Now, there may be some things that unite them, but still there's a great deal that divides them. The Balkanization of originalism is what happens when even our greatest hitherto living constitutionalist becomes an originalist and calls his theory living originalism. Now, I want to begin by saying that many understand originalism quite inclusively, and that's how they can kind of absorb a lot of theories of constitutional change traditionally associated with the tradition of living constitutionalism within originalism. And there's also a worry that I want to introduce through an analogy to something Katharine McKinnon once said. Katharine McKinnon opened Feminism Unmodified with a statement that Marxists said Marxism and feminism are one, and that one is Marxism. And I get the sense that some originalists are getting a little wary about these inclusive versions of originalism, and they worry that if originalism and living constitutionalism are one, that one is going to be living constitutionalism. And I think this kind of worry came to a head recently in a piece by Nelson Lund, worrying about Stephen Calabrese signing on with Jack and his living originalism, and Steve Smith on balkanization in the last week or so was moved to ask, are we all really now living originalists? So there's a kind of worry about originalism getting so capacious, taking on board so much living constitutionalism, that originalism is going to lose its distinctiveness and it's going to become, in terms of my paraphrase of McKinnon, living constitutionalism. So let me just open with those remarks and see what anyone wants to say about where we are in these debates. Jack's just been writing about this on balkanization.
Do you want me to say something about this particular thing? Oh, gee. Hey, guys. It's so nice to see you. I hope you're enjoying your dinner. Anyway, I have some water, so that's it. So as for the question, I mean, Larry can say more technical things, but I guess I would say, I'll be very controversial, and say that the struggle is over. It's over. Living originalism and living constitutionalism are the same thing. In fact, they've always been the same thing, because originalism, the modern form of originalism, which dates from the middle of the 20th century, is itself part of movement politics. And so it was always a kind of a living constitutionalism. As a methodology, the merger was made possible, as a theoretical methodology, the merger was made possible really by Antonin Scalia telling us that he was for original meaning and not for original intention, and Larry can explain why that's so in much better detail than I can. And so in some sense, once that move was made, a distinction that Larry has popularized between interpreting the original meaning and constructing the Constitution, implementing it, making it work in practice, was really just a short step away. And once that was there, then basically there's nothing that keeps you from leading to something like a merger of the two. So that's at a theoretical level. But in fact, originalism was never simply a theory, it was also a cultural trope. It was a trope that's very American. It's not the case in most other countries, and it has to do with our revolutionary tradition, and it has to do with how Americans understand themselves as a nation. And that's not gone. That's going to live forever, because as long as there's a particular constitutional culture in the United States, there will be a culture of originalism. But we should distinguish originalism as a cultural trope from the particular theoretical debates that were waged over a number of decades. Those debates, as far as I'm concerned, are over. But of course, my friends will disagree with me and they'll say, no, they're not over. We've just begun. What do you think, Larry?
Yeah, well, so thank you so much for the opportunity to join you. Thank you especially to Richard for inviting me. And it's such a great pleasure to be on this panel. I want to agree with a couple of things that Jack said, and then I want to express some disagreement. So first thing is that I think Jack is absolutely right that Antonin Scalia's move from the original intentions of the framers to the original public meaning of the constitutional text is what opened the door to the so-called new originalism. It is telling that the sort of in the early history of that movement, one of the key articles, Randy Barnett's article, was called "An Originalism for Non-Originalists," right? And the reason it's important is because once you are talking about the original meaning of the text, then it is theoretically possible, and in fact quite likely, that some things that the Constitution means will have implications that are unintended consequences, that could not have been envisioned by the people who drafted the language. This is, of course, a familiar phenomenon. I'm sure people in the room have drafted statutes. Many of us have drafted early versions of judicial opinions and things like rules for faculties. And one of the things you learn when you draft is that no matter how careful you are, the rules that you draft, if they are big and complex, are likely to have unintended consequences. And of course, originalism as a cultural movement was conservative, right? It was against change. And so this idea that the original meaning could lead to unintended consequences came as an unpleasant and unwelcome development to many conservative originalists. And at the same time, it opened the door for new kinds of originalists, libertarian originalists, progressive originalists, right? And that's certainly been a major development. And I want to agree with Jack that there is a sense in which some versions of originalism are compatible with some versions of living constitutionalism. Right, let's just call that compatibilism. But it really does depend on the details. And so it depends on what kind of originalist you are. There are many attempts within originalism to make the original meaning of the Constitution more constraining. Right, so one of the big movements in originalism now is towards default rules, right? So this is actually an idea that goes back to the 1990s. Gary Lawson down the street at Boston University, Michael Paulson are associated with the idea that when the meaning of the Constitution is unclear, we do not do as Jack does, which is look to the underlying purpose or spirit of constitutional provision, the principle that's associated with the text. Instead, we defer to democratic institutions. That form of originalism is not particularly compatible with living constitutionalism, but the same thing is true on the other side. So the title of the panel invites us to think about fidelity and constitutional change. So not all forms of living constitutionalism have fidelity, at least in the sense that I understand it, as a significant value. Fidelity to the text, right? So just to give a couple of examples, the common law constitutionalism of David Strauss does not incorporate an idea that we should strictly observe a value of fidelity to the text. Right? David Strauss is open to the idea that courts could, in a common law fashion, depart from the meaning of the text, override the text, nullify the text, right? Another version of this, associated with Philip Bobbitt's theory, which has the arcane name Multiple Modalities of Constitutional Argument. Stephen Griffin, Dick Fallon, both have versions of this theory, right? So one of Bobbitt's key moves in his development of the idea that constitutional law is the outcome of a complex argumentative practice is to say that there are several modalities of constitutional argument. Arguments from the text is one of the modalities, but there is no hierarchy, right? There's no rule that says text arguments beat history arguments, or text arguments beat precedent arguments, or that text arguments beat arguments from constitutional values. And that means that pluralists are, at least in principle, open to the possibility that we would override the text. Well, that form of living constitutionalism is not compatible with originalism, right? Now, I want to say one more thing, and then we can turn to another topic, which is that I believe that the wars we're seeing currently about what originalism is reflect the fact that we are, and over what fidelity means, reflect the fact that we're in a period of what philosophers of language call metalinguistic negotiation. Right? Disagreements that appear to be about substance sometimes are actually attempts to change our conceptual vocabulary, to get us to divide up the world in a different way. So everyone wants to claim fidelity for a value, but in order to do that, you might have to change the meaning of fidelity. Critics of originalism want to say, well, you know, now that Jack Balkin is an originalist, the word has lost its meaning, right?
Well, critics of me, not critics of originalism.
Critics of Jack Balkin, the word originalism is losing its meaning, and likewise from the conservative side, right? This is the phenomenon that Jim pointed to. People are saying, well, that's not real originalism. Right? They're contesting our concepts. And this is a very common phenomenon in theoretical discourse, but often goes unnoticed. Okay.
Is that like No True Scotsman?
Yes, No True Scotsman.
Yeah.
Well, thank you very much for my invitation to the panel. I'm going to offer a comparative perspective on the question. And my comparative perspective suggests to me that fidelity and change are concepts that don't need to be understood through the originalism, living constitutionalism, living originalism frameworks, although there are salient features of those frameworks that are being lived out and practiced around the world. I think a very exciting, different framework, which doesn't cede to the territory of originalism, the idea of fidelity, is the framework of transformative constitutionalism. And this framework is best articulated in the context of the South African post-apartheid constitution of 1996, a constitution which was put in place not only to preserve the constitutional settlement reached at that time, but also to entrench a spirit of transformation in the document. The idea that apartheid would never again occur in constitutional terms, but also that the legacies of apartheid would be addressed through a spirit of transforming the laws under apartheid, through a constant realization of not only the inevitability of change, but the invitation to change. So I think transformative constitutionalism is a really interesting way in which fidelity and change are mediated. And let me just cite the kind of prominent attitude towards this in South Africa. And these are words of Deputy Chief Justice Moseneke, who said that the judiciary is commanded to observe with unfailing fidelity the transformative mission of the Constitution. So I think that's a great articulation of how these notions of fidelity are really inculcated in the South African vision. And this is a vision that's not parochial to South Africa, but is actually a vision articulated in many post-conflict, many post-colonial constitutions. We can look to the constitutionalism of the Global South for many examples, India, for example, Colombia, but also we can see versions of transformation here in the United States at the federal constitutional level and at the state constitutional level. And I think looking at those versions of the spirit of transformation, it's a very worthwhile practice. I think living constitutionalism advocates are performing some of this, but maybe losing sight of faithfulness and fidelity that is still a part of the transformative project. I can speak more about what the constitutionalism entails that seeks out transformation, because it's not the fact that everything is up for grabs, despite the fact that everything is shaken up. What isn't up for grabs is what was reached in the settlement to address the legacies of apartheid in South Africa, including the protection of economic and social rights, the recognition that the Constitution would have horizontal application and would affect private relations as well as relations between the government directly and individuals. And thirdly, bringing about a culture of justification within the constitutional document, a recognition that the government would be able to limit constitutional rights sometimes, but that practice of limitation had to be guided by very strict notions of what is reasonable and justifiable in an open and democratic society. These are terms that appear in many other constitutional orders, but what those terms invite and the practice of judicial applications of the culture of justification invites looks very different from what originalists would want to see, because already there are standards that have to be assessed and evaluated over time, and change has to be incorporated within that spirit. Practices going on around the rest of the world have to be included. So this is a very different version of fidelity and change that we're seeing in present-day comparative theory.
I want to make an analogy, and it is an analogy and not an equation, because transformative constitutionalism is a feature of the particular situation of the world following World War II and the post-colonial experience. And therefore, you should understand it on its own terms as a historical event. I want to draw an analogy, however, to the late 18th century and to the post-colonial experience of the American Revolution. It's post-colonial, and it could be understood in terms of the concept of transformative constitutionalism in the following way, without claiming that it's an equation. First of all, you have a revolution. The revolution then has to be, it looks like it's about to fail. You have to have some way of basically making the revolution go forward. They settle upon a constitution. And the purpose or abiding spirit or underlying purpose of the Constitution is to rid the country of the vestiges of aristocracy and monarchism. That is to say, they understand themselves to be a republic, and they understand that their revolution is not merely a revolution about law, but also a revolution about society. And this is the Radicalism of the American Revolution, the book by Gordon Wood. And so in that sense, it is similar to, and the assumption also is that it has to be a revolution in society, cannot merely be a revolution. But at the same time, certain features, for example, the rule of law, the protection of property rights by courts, these very experimental ideas of separation of powers have to be maintained in order to secure liberty over time. I would say, and then of course there's another episode, as you mentioned, which occurs in the wake of the Civil War, which is an attempt, in the words of Lincoln, to redeem the promises of the Declaration of Independence and make them a permanent part of the American constitutional tradition. And he has a very famous speech on Dred Scott, in which he speaks of the Declaration as words which could not be true in their own time, but were made so that they would be true in another time, right? So this idea of a trajectory moving from the past to the future, of commitments which are to be realized in time, in history, is an idea which has an analogy in features of the United States. And I call these features redemptive. I think of them as redemptive constitutionalism. Now, I want to point out that there could be important differences between the South African conception of transformative constitution and the idea of redemption, or the idea of the declaration is promised to be redeemed. First of all, the contexts are quite different. But second of all, transformation in the South African context is tied to a particular set of concerns. It's not tied to others. Redemption in the American context does not have any defining limiting point. That is, redemption could be a redemption of our spirit, of our social life. It could be of the organization of our practices. It could be a redemption of the conception of equality. It could be a redemption of the conception of liberty. So we should understand that even though there's some similarity between these ideas are not the same.
In the 1980s, I wrote an article called Originalism as Transformative Politics. And the theme of that article was that, properly understood, originalism was at its core transformative. Right? So what I'd like to suggest is that we're seeing an example here of the ways in which the normative overtones, ideological overtones of a concept shape the way that we want to use the concept. So I think that South African constitutional practice is highly originalist in nature, and that all of the features that we've just heard about are, in fact, originalist features. For instance, the idea that we would look comparatively, right? Now, this is not something that the South African courts have imposed on the Constitution in a way that's inconsistent with the text. This is a commitment that directly follows from the meaning of the text, right? The idea that a constitution could be transformative is not necessarily an anti-originalist idea if the text of the Constitution includes commitments to transformation. Then originalism is in fact transformative. Now, let me just give another example, the Puerto Rican Constitution, because I think it's quite interesting. So Puerto Rico in the post-war era developed a highly progressive constitution for its time, with a commitment to social equality, to labor rights, lots of provisions that are clearly, in terms of politics and ideology, associated with progressivism. However, politics in Puerto Rico changed. And so in Puerto Rico now, the judiciary is ideologically much more conservative than the Puerto Rican Constitution. So then you ask yourself, as a constitutional theorist, what do you do in those circumstances when you have a living constitutionalist judiciary transforming a progressive constitution into a conservative constitution? And the answer is originalism, of course. Right? I'm right now directing a dissertation on this very topic, right, by a young Puerto Rican legal scholar whose mother is a constitutional law scholar and whose grandfather was the primary architect of the Puerto Rican Constitution. And he's very interested in originalism, right, because he wants Puerto Rican constitutional law to return to the clear and unequivocal commitments of the text. Right? The political valence of originalism depends on politics, on the political situation. the transformative provisions of the Reconstruction Constitution were undermined by a living constitutionalist court, right? Many of the provisions of post-World War II constitutions elsewhere in the world, Puerto Rico is just one example, right, are under assault by living constitutionalist courts. So to me, it's not an easy assumption that transformation and originalism are opposed.
Can I make a comment on that? I think that the moderation is going to be a challenge, but I do find the originalist frame somewhat a constricting frame from a comparative point of view, because the valence of the concept is so different in the United States, and one can imagine that it would operate very differently in a young constitution than in a very old one, because originalism would not be so controversial, but you wouldn't want to defer too much to what your just previous generation had said about the Constitution. Where I see the work doing in a constitutional document is through a theory of constitutionalism. That is, a theory that the document is there for a purpose, and that purpose is to constrain government. Fidelity then comes across through run-of-the-mill bread and butter constitutionalism, and you don't need an additional theory of originalism to justify the respect accorded to that founding constitutional moment and what was meant at that time. So I wouldn't suggest, originalism can be a very colonizing concept, but I wouldn't suggest one needs to take that step to understand the phenomenology of constitutional interpretation going on around the world. That said, if you do it, and I think there's really interesting comparative work being done on this topic, and what you mentioned about the Puerto Rican Constitution sounds very much similar to this. So there's been studies on the Turkish Constitutional Court and the incorporation of originalist arguments in Turkey to justify a particular version of secularism that was there at the founding to overturn legislation against headscarf wearing in educational institutions. There's also been important work on Southeast Asia, the fact that there are discourses going on in Malaysia that are originalist in character, and that there are modes of constitutional interpretation going on in Singapore that look originalist in character. Now, all of these examples actually do shake up the terms of originalism as understood in the United States. So I think these are really interesting comparative examples that help unsettle the meaning of originalism here and do very much what you both are doing in relation to US originalism. So I think that is a great version of comparative practice, and it looks rather different from the first wave of comparative practice on this subject, which I would suggest did look to Australia, my own country, to see the versions of originalism that were being used both by High Court justices and by constitutional commentators in Australia, and used very self-consciously in relation to American debates about originalism. So I think you could almost argue that American originalism was being exported at that time to Australia, and there was a really interesting dialogue going on between the two. Now, the second wave of comparative analysis is looking at places which are not self-consciously using American versions of originalism, but are actually using their own, which makes sense to much younger constitutional documents, and really change the battle lines between conservative and progressive arguments, or secular and religious arguments, and really throw up the battle lines that we understand as the battle lines of originalism here. So I think those comparative examples are really great, but the warning is, if everything is understood to be originalism and not constitutionalism, what is there left for us to really disagree about?
We're already well into my second series of questions, which were going to be about originalism and comparative perspective. And the conventional wisdom has been that originalism is very much an American phenomenon, and that originalism has little appeal elsewhere in the world. And Jack was alluding to the first part of that conventional wisdom, that it's very much an American phenomenon growing out of our revolutionary experience and the like. Now, in recent years, some, most notably Jeff Goldsworthy, an Australian constitutional theorist, have challenged this conventional wisdom, but even he seems to concede that only what he calls moderate originalism, rather than strong or narrow versions of originalism, have any appeal in other constitutional cultures. So what are the prospects for exporting originalism to other constitutional cultures? And how moderate or how inclusive would originalism have to be to become acceptable in these other constitutional cultures? Would originalists have to transform originalism considerably in order for it to gain a foothold in other constitutional cultures? And so I guess now that I've put those questions, we're right where you ended.
Yeah, but there are several things that we need to distinguish. One is there's these academic theories of originalism, claim about how to read a text or what's the appropriate way of interpreting a text. Okay? Then there's the politics of originalism as it exists in the United States, which has tended to be conservative because it's allied with a social mobilization. And then there's the cultural trope of a return to origins, of which originalism, quote, originalism, the American phenomenon, is simply an example of many of things and among many. So if you want, you can call them originalism, but that's like calling something that occurs in the 20th, calling something that occurred in the 5th century in Athens something that occurs in the 21st century. It's basically anachronistic. If you think about the processes of change within a society, once you recognize that the generation which produced something of value is passed away and a new generation takes its place, then there's a sense that you are no longer of that generation and something has departed. At that point, you have to make a decision about how you meet change. And there are very standard cultural tropes for doing this. You can call them originalist or not, but it's not the point. One is the idea of recognizing and accepting the existence of change and that you must go forward and that the past is something which you now transcend, right? You move forward from it. It no longer has a particular hold on you. The other is the opposite, which is the sense that something has gone wrong and that you need to redeem and restore and return to some valued event in the past. This is, you can understand this in religious terms, right? If you think about Martin Luther talking about returning to the early church fathers and their sense of faith, this is Protestant Reformation. It's radical in its origins, but it's also a backward-looking conception of to purify, redeem, and restore a particular tradition. And if you think about South Africa, in South Africa, you have the first generation of people who basically create the settlement, but they are all dying or dead. And now you have a new generation. The question is, what are we going to do with the experiment in governments we call South Africa? What are we going to say about it? And so you're going to see the same tropes emerging in different ways. It may not be in academic theories about the Constitution, but they'll be in politics, they'll be in rhetoric. And many of the examples that you were mentioning in Malaysia and in Turkey are examples of this cultural trope of return, or attempting to go back to what is thought to be a more pure or echt or significant or symbolic version of the nation and what it means, what it stands for. This can be completely separated from the academic question of how is language work and how do you interpret the meaning of a word, which are very, very different kinds of debates. This feature of change with a constitutional order is universal. It's not American, and America is just a special case of it. And the way it happens in each country will have very much to do with the country's national narratives and the particular way in which its constitution was founded. For example, in some places, the Constitution is not a particularly important political document. It's a legal document. It's a document for lawyers. In America, the Constitution is embedded with all of these values in it. The Constitution is seen as the civic religion, the scripture. But this is not true of most other countries in the world. And so when we try to import these ideas into other countries, people will shrug their shoulders and say, well, that's not what we do with our Constitution. That's not how our Constitution works. And it's not the way we remember the past. We remember the past through other ways, and we have our fights in other ways. So when Goldsworthy was talking about Australia, he was saying, when we have fights over social rights in Australia, we don't go back talking about the Australian Constitution. That's not the way we do it. We have other things we remember. We have other tropes that we draw on. But the one thing we don't draw on is the Australian Constitution. What's weird or interesting or unusual about America is we're about to have this big fight over same-sex marriage, Obergefell versus Hodges. It'll be argued next week. Guess what? This is all being fought over in terms of the meaning of the Constitution. It's all being fought over in terms of the meaning of the Equal Protection Clause, for example. That's how we do it in the United States. It's not how you would do it in France. They passed a statute. It's not how they do it in Canada. It's how they do it here. And what's interesting is that the fight of originalism now has gotten, if I may say, wedded to the fight over same-sex marriage, because some originalists like me think this is a perfect example of how originalism is completely consistent with a constitution, living constitution. And other originalists are saying, oh my God, the sky is falling. If this can be justified in originalist grounds, there is nothing left to originalism. It has been exploded and made into something worthless. That fight, though, is a fight about the Constitution.
This sets up my next series of questions, but Larry, do you want to come in on this before we move?
Just in a tiny little way, which is to say that I think Jeff Goldsworthy is a great example of the fact that originalism is not necessarily being exported from the United States, right? Because Goldsworthy, I'm actually having a meeting, I'm making the pilgrimage to Melbourne to talk with Goldsworthy in 3 weeks. And many of the ideas associated with contemporary originalism were first articulated by an Australian, right? And then the migration goes the other way, from Australia to the United States. So and of course this is, we don't, sometimes American constitutionalists tend to have a very jingoistic sense of what constitutionalism about, but I just don't think that it's factually correct that constitutional theories flow like originalism flow out of the United States, or that ideas like proportionality that we associate with European constitutional tradition are really necessarily European in origin.
Can I?
Yeah.
I'll just answer the point about Australia. There's a lot of other things opened up here. But it's true, I think Jeff Goldsworthy coined the scholarly term originalism before it appeared in print here. There were original notions of original understanding expressed here in publications. And Jeff Goldsworthy described originalism in Australia in the early 1990s. And there's this really interesting interplay between American ideas and Australian ideas. But I don't want to suggest that Goldsworthy is really presenting the mainstream view of constitutional interpretation in Australia. Originalism is a very, has been but is growing, but has been a very marginal ideal of constitutional interpretation. In fact, the early interpretations of the Constitution that the High Court had to make, they were prohibited from looking at the founding debates. So originalism was off the table in the earliest experience of the High Court of Australia. Now,
Can I just intervene right there for just a second? And many contemporary American originalists believe that the debates and the history of the framing are off the table because, as Justice Scalia tells us, it's about the public meaning of the text, not the intentions of the framers, not what James, not, we don't try to channel
they may
James
say that,
Madison.
they say that, but they don't practice it.
Some of them do and some of them don't.
but a final point about the Australian Constitution, you mentioned Jeffrey Goldsworthy, as one voice of constitutional interpretation in Australia, sees it as a very basic law that doesn't invite the same soul-searching as American constitutional law invites. Now, that also is somewhat inaccurate. And it's also somewhat corresponding to present-day constitutional discourse in Australia. But if you cast your minds back 20 years, you wouldn't find the same discourse. So there were big debates 20 years ago as to whether there should be a freedom of political communication implied in the text of the Constitution. A very progressive High Court made that step, and there was a cascading effect on what else could be included in this constitutional document. And a very mobilized constitutional discourse for a short time, including a discourse as to whether native title rights should be recognised in the Australian Constitution. We have a debate going on now whether Indigenous rights should be recognised through a constitutional amendment. So I think it's not true to say that a kind of public spirit of constitutionalism is not alive in Australia, although it may not seem to have the same resonance that it has, I think, very much due to the revolutionary spirit here in the United States.
Is it possible that under the Mason Court and they could have guaranteed same-sex marriage under the Australian Constitution, or is that you just can't stretch it that far?
Well, it's a counterfactual. There have been, because of the backlash, which you've
Yes.
theorised well about, there have been a number of conservative appointments to the court. I think if the line of appointments had continued in the Mason tradition, his conception of constitutionalism was broad enough to feature implied rights and to bring about the building blocks for that kind of recognition. But the rest is history because the composition of the court changed.
So what Jack was saying a few moments ago about the argument about same-sex marriage sets up my next series of questions.
So you're always one question behind us.
Well, no, it's just that the questions I framed led you to my next question. Okay. So now, some originalists, in either unreflective or unguarded moments, have talked as if originalism is that's just what interpretation just is, as a matter of fact. Okay. Now, that view has largely been abandoned within originalism, and people realize they've got to make normative arguments for originalism. And so we've seen a series of normative arguments for originalism. But Will Bode of University of Chicago has taken a new tack in this in a recent piece, Is Originalism Our Law? He basically says, well, let's leave aside the normative arguments. I just want to make a positivist case that originalism is our law. And that's the way we argue around here, in the way Jack was putting it. Now, one thing critics of that view sometimes point out is that, well, if originalism is our law, then why is it that originalists are always complaining about all the precedents that are not originalist? And originalism, to be our law, would have to be awfully capacious. It couldn't be originalism as in any conventional understanding. So in this piece, Is Originalism Our Law?, Bode argues that many precedents commonly thought to be anti-originalist are not, in fact, incompatible with originalism. He goes through cases like Roe and Lawrence and notes that some originalists argue that there is an originalist case for right to same-sex marriage. And he wants to say, yet there's no denying that conventional originalists like Bork and Scalia have argued on originalist grounds that cases like Roe and Lawrence are wrongly decided, and they've argued on originalist grounds against any right to same-sex marriage. And conventional originalists have resisted change in constitutional understandings of the sort that originalists would have to accept in order to be able to make an originalist case for the right to same-sex marriage. So I want to ask, can there be persuasive originalist arguments for Roe? I know Jack thinks there can be. For Lawrence, or for a right to same-sex marriage? And there's been a debate on your blog recently between you and Steve Smith and various other people, and there's been a debate over certain briefs, amicus briefs, in the same-sex marriage case. So can there be a persuasive originalist argument for a right to same-sex marriage? Or in making such arguments, have originalists given up the game to living constitutionalists and moral readers? That seems to be the suggestion of Steve Smith's piece. Go ahead.
So, Steve Smith's a great example of the discomfort caused to originalists by Scalia's move to public meaning. And the little mini symposium, I think it was on the Liberty and Law blog that Jim was referring to, Steve Smith, who's a former colleague of mine, professor at the University of San Diego School of Law, argues we need to move away from Scalia's view and to a different view, which he calls the original decision, right? And I'm frankly mystified by what the original decision is. The best I can understand it is that Steve is suggesting that we move back to the view that what we're trying to do is figure out what would the framers do about this particular issue, right? That view is doomed, right? It's just doomed. That will not work as a method of constitutional interpretation.
Framers themselves wouldn't have used it.
Among other things, right? I mean, that's not the most serious problem. But but let me talk.
Scalia's view wouldn't get you to same-sex marriage either, unless somehow that
unless
that opens the door to
yeah.
like
Let's just talk about. So Scalia, of course, is not terribly consistent about any of this stuff, right? He might be becoming a little more consistent, actually, I think, as he ages, but he certainly was very inconsistent for a long time. So let me just talk about same-sex marriage and two parts of the first section of the 14th Amendment. I want to just set aside the due process clause. I think no originalists think that substantive due process will get you there, right? Because they tend to believe that it's a procedural due process clause and not a substantive due process clause. But there are two other clauses, the Equal Protection Clause, right? And Jack has made some arguments, and there is a very fine brief making some arguments.
That's the Cato brief.
The Cato brief, and these are not wild left-wing progressives, by the way, but they are libertarians, that the Equal Protection Clause expresses an anti-caste principle, and that although people at the time would not have seen the implications of this principle, why not? Because there were very strong social norms, deeply held, widely shared social norms that made the idea of recognizing gay marriage sort of inconceivable at the time. When the social norms give way, and they haven't given way fully, hence the resistance, when the social norms give way, then a piece of text that might not have been thought to have this implication, suddenly it may start to become possible that it has this implication. And then later, right, if the social norms fully adjust, it might come to be seen as inevitable and obvious that that's the meaning of a constitutional provision. Now that's going to be resisted, right? That's going to be resisted, but it doesn't mean that it's not the result. The resistance is coming from other sources, not necessarily from a belief that the text does not have this implication. Now, having said all that, I do not think you can make a good Equal Protection Clause argument for same-sex marriage for a very different reason than is discussed by many conservatives, people like Steve Smith. I think it's the protection of the laws clause. It's all about protecting people from invasions of their basic rights. And in the context, the exemplars of this that the people had in mind were protections of the laws against invasions of personal security and property, right? And so I'm not sure you can get there from the Equal Protection Clause, but there's another clause in the 14th Amendment, the Privileges or Immunities Clause, right? Now this is a clause that was nullified by the Supreme Court. We're all familiar with Slaughterhouse and Cruikshank, right? It's a clause, the meaning of which is hotly disputed. But here's a possibility. It clearly referred to basic rights, including rights to, now this is substantive, the basic right to, that were guaranteed by the Bill of Rights, maybe those were among the privileges or immunities. Is the right to marry a basic civil right? Would it have been considered a violation of the Equal Protection Clause to deny the former slaves the right to marry? Excuse me, the Privileges and Immunities Clause, the right to marry? Possibly. And if that would have been a violation of the Equal Protection Clause and the social norms have changed, then maybe there is a Privileges or Immunities Clause, a perfectly good, perfectly ordinary argument that there is a right to same-sex marriage that flows from the Equal Protection Clause, just a right we could not see because we were in the grips of social norms that made it unthinkable.
the same-sex marriage issue is one reason that I find it difficult to cede the territory to originalism, because I think it's dangerous territory for a viewpoint like this, and I think moral readers would have a much stronger case to bring same-sex marriage into the American constitutionalism. But it's an interesting case study to look at the practice of fidelity in South Africa, because the issue of same-sex marriage was resolved very quickly by the South African Constitutional Court, as required by the Constitution. At the time of drafting the Constitution, the constitutional negotiators would not say whether they were for or against same-sex marriage. They instead included a very broad equality protection and left that work for another day. Likewise, the issue of the death penalty. This was a very contested, very heated issue in South Africa at the time of drafting the Constitution. The drafters themselves saw it as an incredibly important issue for South Africa, but they did not resolve it at the time of drafting. They left it for another day. And by leaving it for another day, they left it for another forum, the Constitutional Court. And those two issues were then resolved in favour of a moral reading, in favour of transformative constitutionalism by the Constitutional Court, without relying on what the framers had decided, because there was the acknowledgement that these were actually issues that were left open. So I think that is kind of a telling case study about the treatment of fidelity within a system that has to resolve very contentious issues that do go against public opinion, that need to be resolved somehow, and that have been resolved that way in South Africa.
Well, actually, I have to say that that's an originalist story. I'm sorry, it is. Let me just, it has to go with what you think a constitution's about. So, if you think that a constitution is a combination of different kinds of norms that deliberately are open-ended and leave things open for the future, that's part of the original plan. And the point of the plan is that you delegate to the future the articulation and implementation of these norms in their own time. That's exactly what the framers of the South African Constitution appear to have done. And that's exactly what was done later on by the Supreme Court of South Africa. That's actually originalist. That's based on a particular conception of what a constitution is. So a constitution, in my view, is an unfinished product. It's the beginning of something. It's not the end of something. It's a framework. It's not a skyscraper. And in that sense, if you understand how a constitution is constructed and why it's constructed the way it is, then nothing could be more natural than the Constitution will be implemented over time, and you will reach views that, in fact, some people might not have agreed of if you had asked the framers. Same thing happened, by the way, in the American Constitution over the growth of the national state. Same issue arose. And it's the same idea. Things were left open and they were developed over time. That's as originalist as they come. But if by originalism you mean the trope, that we go back and ask the wise people who founded the nation what they would have done, and that we try to imbibe their wisdom, no, that's not that at all. It's a different way of thinking about a constitution.
You know, we could go on for the whole evening about these questions, and I've got a whole bunch of other questions, but I want to open it up to the audience if there are any questions or comments anyone has about these or any other issues.
Do you think James Madison would have opened it up to questions?
Steve.
I'm convinced that James would have opened it up to questions all the time. But I wanted to...
Oh, this is Steve Gottlieb from Albany.
Thank you.
You and James were on first name basis?
Oh, all the time.
Because we double dated, actually. Yeah, there you are.
Well, I went to Princeton. His spirit is abuses.
There you go.
But I'm wondering if another piece of the unity of all the approaches to constitutional interpretation that you're thinking of, and I'm not sure how far I can extend it on a comparative basis to many of the places that you've talked about, but probably not all. But at least as that discussion goes on here, is there a small d democratic premise under all of them? I'll take that answer.
I think the notion, I'll suggest an answer. The notion of transformative constitutionalism in South Africa does delegate a great deal to the court to resolve. So it has been critiqued as somewhat jurist-centric in character. And there have been competing conceptions of transformative constitutionalism that would like to see it democratized and owned by the people as a cultural trope, really, in South Africa. I think that's an important challenge for transformative constitutionalism, just how much it expects a court to do.
Vlad.
Just like a quick question about whatever, if anything, happened to Dworkin. So there is this moment when Dworkin says that he's the real originalist because he's the one who looks at the general concepts of equal protection and liberty, and then you go and interpret that. And I think that in some way that conception of Dworkinian originalism, if you will, is quite connected to Katie's idea of constitutionalism. You don't need anything added on to constitutionalism in order to get that. And I think that there is in Professor Balkin's conception, there's some affinity there, only that from the Dworkinian perhaps conception or approach seems to be far less patient with arguments from culture and far less patient with arguments from social norms. So there you cannot dismiss either, say that you cannot dismiss the comparative example, you cannot dismiss any examples as just being part of a different culture, being made at a different time. There you have to engage normatively with the ideas. And this is a certain conception of normativity of you. That seems to be quite important, and I just wonder how you feel in relation to that, because it seems that in your conception, culture does quite a lot of work, as does a certain very sophisticated conception of social norms. So I just wonder how you feel in relation to that sort of Dworkinian insight about the normativity of constitution.
I want to interject something here. I've just finished a book, Fidelity to Our Imperfect Constitution, 4 moral readings and against originalism. And so I've tried to reclaim fidelity from the originalists for the moral readers and made all these moves. And one of the chapters in the book is an engagement with Jack's living originalism. And I put this, in my words, put the very same question to him. How does this relate to Dworkinian moral reading? Because it sounds like the constitutional commitments are abstract principles. It sounds like the relevant original meaning to which fidelity might be owed is that of abstract moral principles. But I think you're, as I interpret Jack, you're right on the right track in understanding why he would want to differentiate his own view, which he concedes is in a general way a moral reading, from Dworkin's view. It's things like the social movement's role in contesting norms. It's things like a Protestant constitutional culture as opposed to a very court-centered constitutional culture, and all the rest of it. But it's that was one of the questions that I meant to follow from the question: are we really all moral readers if we're making arguments for same-sex marriage and saying, well, I guess it's consistent with the abstract original meaning of the Privileges or Immunities Clause or the Equal Protection Clause or commitments to ordered liberty. Jack?
To be compared to Ronald Dworkin is an enormous compliment, so I don't have any problem with that. It's just that it's very important for us now that Dworkin has passed away to try to understand him in the context of his time, as opposed to a living person that you're fighting with, right? So now you can take the measure of him and what he was doing in his own time. And what he was doing, in some sense, is he was emerging out of the legal process school in the United States, which was very centered on the internal workings of courts and the relationships to legislatures. He was a legal process guy, and many of his examples, the classic example about the will and the guy kills his uncle, that's taken from the legal process materials. That's actually cribbed from Hart and Sachs. And so he's coming out of legal process, and what he's trying to do is he's trying to give an account of how you can have a legitimate revolution in civil liberties, civil rights and civil liberties at this moment in American history. And he's the great champion of these developments in American law. And through that, he develops his his jurisprudence of principle and the concept-conception distinction. But you have to understand that for his generation, these things were not understood as arising from popular mobilization. They were understood as being something that very smart people who had the right sort of values and could argue about law could reason to. And the irony of Dworkin, and also Alex Bickel, who was at his school at the same time and is a little older, was that these people were thinking about these questions of principle and civil liberties at the very moment when they were surrounded by some of the most important popular mobilizations in American history. These were mobilizations seeking equality for black people, an expansion of civil liberties, a reform of the criminal justice system, and even protection at the beginnings of the sexual revolution. And these things come not simply from legal elites, they come from a larger society, and legal elites soak them up, and they rationalize them, and they make sense of them, and they philosophize about them. And so the biggest difference between Dworkin and me is not that one of us likes principles and the other doesn't, but one of them is always paying attention to where these arguments come from. The fact that we're now having an argument over same-sex marriage is because there has been a decades-long struggle by sexual orientation minorities to have themselves regarded as equal citizens. And that decades-long struggle has been aided and helped by many important lawyers, but it's now bearing fruit and it's now appearing before the Supreme Court. But the Supreme Court is the last stage in this process. It's not the first stage. And that's really the big difference between the way Dworkin imagined these things and I imagine them.
So it's originalism is origins, right?
Yeah, and the word origin has two meanings. The word origin has the meaning of the beginning, but also the origin and the movement away from the origin.
And I think there's another,
Since we have only a few more minutes, shall we let some more questions come in?
Sure.
And then we can have a chance to say a few words at the very end. Yes, go ahead.
I'm not a student of law, but I remember reading Blackstone, and he made a clear point that the natural law is the foundation of law. My question to you, what do you say of it in terms of natural law, and is that the death knell because of same-sex marriage?
It's a fabulous question. There are many different accounts of what natural law is. If you understand natural law as the adaptation of positive norms to the way in which human beings live and the goods for human beings, you could have either a static conception of the goods for human beings or a dynamic conception of the goods for human beings. If you take the former, then obviously you can't have same-sex marriage. If you take the latter, then obviously you can.
Anybody else in the audience? Why don't each of you, if you like, take a minute or two with any final thoughts on...
I don't want to cut you off.
Yes, why don't you
Larry,
talk
go
about this?
ahead.
just wanted to say a couple, so I agree with everything that Jack said about Dworkin, but I think there's another difference between Jack and Dworkin, and it goes to whether or not Dworkin is any kind of an originalist, right? So the first thing I want to say is that Dworkin is very explicit in saying that judges can override the text of the Constitution, right? In exchange with Larry Tribe, where Tribe has said the text is always primary, Dworkin says, that's a stronger statement of textual fidelity than I would myself endorse, because as I said, precedent and practice over time can in principle supersede even so basic a piece of interpretive data as the Constitution's text, right? So, second thing, when we think about Dworkin as having sort of an originalist flavor, it's because of his concept-conception distinction argument, right? This is the argument that the Constitution points to what are sometimes called contested concepts, what Dworkin calls interpretive concepts, like equality. And the idea is that there's the concept of equality, but people disagree about the nature of equality. The Constitution, Dworkin says, enshrines the general concept of equality, not any particular conception of it, right? So that could be the case, right? And if so, then Dworkin would be an originalist, assuming that he's got the text right. But it's not necessarily the case. Ordinarily, when these words like equality or cruelty right, are used by speakers, we use them to express our own conception of equality. It's very rare, vanishingly rare, usually only occurs in theoretical discourse, that you use one of these special conception words in the sense of the general concept. There's a very good reason for that, because the general concept is empty, right? And people don't, it is a vessel to be filled with content, right? And normally when we say things like, you can't deny people equality or no cruel punishments, we have some conception of equality or cruelty in mind. So you can't make the assumption that Dworkin, in my opinion, makes dogmatically, that whenever such a word appears in the Constitution, its intended sense is the general concept sense, right? In that, he does not look at evidence to reach these conclusions, right? He just makes the assumption that it must be so. You could look at the history and ask, is this the way they were using the word to point to the general concept, or did they have a conception? But Dworkin doesn't do that. And for that reason, again, Dworkin is not an originalist.
Well, I'm glad to hear that.
I have a comment.
Okay, go
I'll
ahead.
just sum up. Just in terms of, I thought what was very interesting about what you said about Dworkin, theorizing when all of these mobilizations were occurring around him, and I think it's so interesting that you're so perceptive about all the social movements that have been going on around American constitutional law, but not perceptive to the globalization of those social movements, and the fact that constitutional redemption might be a mobilizing force of the past if we understand same-sex marriage to be a very globalized movement of sex equality, and we understand human rights to have globalized constitutional rights, then I think a single constitutionalist redemptive frame might not offer as much as any constitutionalist frame that doesn't rely on an originalist founding moment. And just in terms of how the future is really conceived, my favorite quote about the future is one which recognizes that the future is already here. The future is already here, it's just unevenly distributed. And I think that really speaks to a certain truth, that perhaps constitutionalism can grasp more than your beautifully broad conception of originalism.
Well, this is terrific. Thank you very much. Good evening.